Right, so documents have already started to come out. The one I'm looking at here, I'm going to try to go through the other documents too. This is the defendants' responses to plaintiff's Local Rule 56.1 statement and statement of the additional material facts pursuant to Local Rule 56.1b in opposition to the plaintiff's motion for summary judgment. That might not mean anything to you, it doesn't really matter. Essentially, what's being brought forward in this document, which was 400 and something pages, basically a series of arguments that the SEC claims and the response from Ripple basically saying that's wrong, right? Just from a surface look of this document, just trying to get some of this main information out here for you. Basically, Ripple has been described as a responsible steward of XRP. Responsible, because it does suggest that Ripple's been actively managing its XRP holdings in a way that's actually supposed to support and maintain a liquid market for XRP, which is what XRP needs. And it just shows an added level of commitment on Ripple's side that they want to maintain the value and liquidity of XRP. So there's a few claims that were made and resolutions to these claims that I'm going to go over. One claim is that Ripple is the company that runs XRP. That's what they were claiming, basically saying that Ripple runs XRP, which we know is not true because Ripple and XRP are different. The resolution to that says that it disputes that claim, saying that Ripple works hard every day to clarify that Ripple is a company and XRP is the digital asset that's native to the XRP ledger. There's a distinction there. And then it also says that is set forth in PX93 at 9 to 10 on page 174. So that's all on the screen for you to read if you want to pause. The other claim is that Ripple sold XRP to certain purchasers at bulk or at a discount. Ripple has obviously disputed this claim, stating that to the extent the SEC purports to suggest in paragraph 789 that Ripple sold XRP to certain purchasers in bulk or at a discount, they dispute that because each contract contains particular terms with particular purchasers who bought XRP from XRP2. Remember, XRP2 is the company. It's like a legal subsidiary to do these sales. We covered that in a previous video. Each of whom did so for their own reasons, including to lend or engage in the market-making activity in XRP and on behalf of their own customers. And that's all on page 21. The third claim is that institutional sales purchasers who bought XRP from Ripple at a price that was discounted from then prevailing market prices had incentives to resell that XRP into the market. Basically saying that people who bought at a discount had incentives to sell at a higher price on the secondary market. The resolution was that Ripple disputed this claim, stating that defendants do not dispute that PX 279 contains the quoted text, exclusive of any alterations, omissions, or additions by the SEC. The defendants dispute the SEC's use of the term institutional sales, set forth a fact that can be responded to with, particularly given the SEC's conflicting definitions of the terms in paragraphs 614A and 789 on page 21. So basically what we're saying is that the claim was that institutional sales were being made, and Ripple's response to that was the way the SEC are defining institutional sales is not true to the nature and based on the context of those sales in the first place. So they're basically saying that it's wrong. The fourth claim is that Ripple's trying to change references in articles from Ripple's XRP just to XRP. So throughout the whole thing, it keeps saying Ripple's XRP instead of just XRP, and basically adding to their argument to say, the SEC has an argument to say that Ripple and XRP are the same thing. They want it clarified here that it's not Ripple's XRP. We need to change it just to XRP because Ripple and XRP are separate entities. This is fine. And the final claim, which I actually don't know much about here, is that the Dow report applies to Ripple and XRP. So there seems to be a report called the Dow report, and Ripple dispute this claim, saying that it's undisputed that the Dow report contains the quoted text. However, the defendants dispute the SEC's characterization of and inferences purportedly drawn from the Dow report, including because paragraph 943 omits the additional context necessary to understand the DAO report. So the SEC are using the DAO report to classify XRP and Ripple as being as them being applicable to the DAO report, but Ripple are saying essentially the context, you've left big pieces of context out of that report of what you're defining, and that's not an accurate way to do it. Let's see what else here. Including the DAO report specifically discussed the treatment of digital assets as securities when tokens are sold to raise capital in what have been referred to, among other things, as initial coin offerings. So there's lots there to unpack. Again, this is a 400 and something page document. These are just the main claims that were talked about and the resolutions to those claims. Let's get into the other documents in these following videos. Remember, this whole day is going to be crazy, so stay tuned, stay subscribed, keep your notifications on, because we never know. One of these videos that I make might just be about the Hinman emails. So subscribe. I'll see you in the next one.